Hello and welcome to Topic 8, Lecture 1. And in this lecture, we're going to be learning about the organization of the federal courts. So what are we going to be covering in this lecture? Well, the first thing that we're going to do is that we're going to learn about the role that the federal judiciary plays in American government. And so at this point, we've learned about Congress and we've learned about the presidency. And so this is the last federal branch of government that we're going to be learning about. And so we'll learn about how the role that the judiciary plays is different than the role of the other institutions. Next, we're going to learn about the types of cases and law that we have in the United States. And so first we'll learn about the difference between civil and criminal law. And then we'll talk about the types of courts that make up the federal judiciary. And so we'll learn about the difference between trial courts, appellate courts, and Supreme Courts. And then finally, we're going to take a look at how the American judiciary is organized. So we've got a lot to cover. Let's go ahead and get started. So what role does the federal courts play in our institutions of government? Well, as we know, the main function of Congress is to pass laws. And we know that the main function of the presidency and the federal bureaucracy, the 15 departments that are associated with the presidency, that their main job is to execute the laws. So what is the role of the federal courts? Well, the role of the federal courts, really of any courts, is to settle conflicts, okay? And so, in your textbook, they say, the court used to be, where the king is, and that people would come with like that there was some sort of dispute over, property rights or over some rule. And then the king at the court would settle that dispute. Well, in democracies, we have judges and juries who settle conflict that arises between two people or between a person and a corporation, or a person and the government. And so basically courts, when there's a conflict, people will come to the court and then they will present their case, each side. The court will listen to the sides of each case, and then it will apply law and constitutional principle to decide those cases, okay? So just, from a criminal law perspective, that there could be a dispute over whether or not somebody engaged in a crime, right? And so the government will come and they will make a case for how indeed the accused did commit this crime. But then the defense attorney will say, no, my client did not engage in this crime. And then it's up to the judge or the jury to settle that dispute. Now, courts will apply laws and constitutional principles to decide cases. So when it comes to criminal matters, they will interpret laws in order to see whether or not this individual actually engaged in this criminal act. And in civil matters, they will interpret and apply the law as it relates to contracts or as it relates to like personal injury, the responsibility of somebody's actions, etc. And so that is the main function of the court, to settle conflicts. Now, one of the things that the courts use to help in their decision making is obviously they use the law and they use constitutional principles to decide cases. But they also look to the past to help guide their decision making. And what that is called in Latin, it's called stare decisis, okay? Which basically means that we let the decision stand. And so oftentimes when the courts when a new case comes before them, they will look at how the court had ruled in the past, and they will use that past ruling to guide their decision making in the present case. Let's look at two cases as an example. And so we have the District of Columbia. These are both Second Amendment cases. We have the District of Columbia versus Heller, and that we have New York versus Bruen. These are two cases that were heard, maybe about 10 13 years between each other. Heller is the landmark case that basically says that the Second Amendment is interpreted as an individual right to bear arms. The people have an individual right to bear arms. And so it established the decision that when it comes to the Second Amendment, you have the right to have a handgun or any other kind of gun because that's guaranteed by the Second Amendment. Now, Bruen is a case that was decided in 2022, and Bruen was about the state of New York. It had a law that said if you wanted to have a unrestricted license to carry a concealed firearm, you had to prove that you had a special need to carry that firearm. And so there was a conflict over that law, right? On one side, they said, wait a second, that this violates a person's individual rights to carry arms. On the other side, the state of New York said, you still have the right to carry an arm, you just don't have the right to conceal that firearm. And so that dispute came to the Supreme Court, and using Heller and applying Heller, they basically said that no, you do have an individual right to bear arms, and that individual right extends to the right to conceal and carry. But we should keep in mind that courts don't always use past decisions to rule their decision making. A very recent example of that is the abortion case, the Whole Women's Health versus Dobbs. And so in that case, in the Dobbs case, that there was long-standing precedent that women had a right to a constitutional right to an abortion. It was established in Roe v. Wade, and then it was again reaffirmed in the case Planned Parenthood versus Casey. And so there was a long precedent that said that women had a right to a constitutional right to an abortion. In Dobbs, they threw out that they didn't use the past decisions to guide their decision making. They basically said that Roe was wrongly decided, and therefore it does not apply to this case of Dobbs, which was a case where Mississippi passed a law saying that that you couldn't have an abortion after 15 weeks. So while the court usually applies previous cases to guide their decision making, they don't always do that. Okay, so let's move on to look at the two types of law. There are actually three that are talked about in your textbook, but here we're going to be focusing on criminal and civil law, and I'll let you read about administrative law in the textbook. And so what is the difference between criminal law and civil law? Well, criminal law is the branch of law that regulates behavior, defines what a crime is, and defines what the punishment is going to be as well. And so criminal law deals with generally behaviors that are seen to present a harm to the safety, sometimes the morality of a public health of the community. And so clearly robbery, murder, assault all fall in the category of criminal law. But, so does public drunkenness, public exposure. There's a whole host of laws that are defined in state statute and also in federal code that tell us about what constitutes a criminal offense. In criminal law, what's important to keep in mind is that the dispute that is being settled is between the government or the state and the individual. And so the individual is accused of engaging in a behavior that violated criminal statute. And then so the state then basically charges that individual with a crime, accusing them of breaking that criminal law. And so in criminal law, the state is always the plaintiff. That means they're always the entity that brings the charges, and that the individual is always the defendant, okay? And then that dispute will come to the courts, and the courts will settle that after listening to evidence from both sides. Another difference that we're going to see between criminal law and civil law is the evidentiary standard that's used to determine or to settle the dispute. Since in a criminal law, you can be sentenced to incarceration, probation, even you could be sentenced to death. That there's a very high standard to determine the guilt of the individual, and that evidentiary standard is beyond a reasonable doubt. Okay, we want to have a lot of confidence that when the dispute is settled, that there's really no doubt in the minds of the jury or the judge that the accused is the one who committed this crime. Now, on the flip side of that, we have the branch of civil law. And so this is a branch of law that settles non-criminal disputes between individuals or organizations. And so, the most common sorts of civil cases are disputes over a contract or a dispute over who is responsible for committing a personal injury, torts. And so, an example of a civil dispute is suing someone for breach of contract, right? You might have hired somebody to do some landscaping around your yard. They signed and said, yes, we will do it in this time period for this amount of money. And then let's say the landscaper never fulfills that contract. Well, that's a dispute that would be brought to the court and settled to find out not who the guilty party is, but to find out who the responsible party is. Now, in civil law, there is no criminal penalty, okay? You can't, if you're found responsible for violating a contract, they don't send you to jail. But what they can do is they can make you pay a monetary damages, and so that you could say in violating the contract or in violating, injuring somebody's body, that you are responsible for paying these damages. You might also be instructed to fulfill the contract, okay? But there are no criminal penalties, and as such, there is a lower evidentiary standard. In civil law, the evidentiary standard is by a preponderance of evidence. So it's a little bit easier, right? And you say, taking all the evidence, then it seems like this person is the guilty or the responsible party, even though there might be some doubt, okay? So it's actually easier in civil law to find somebody to be the responsible party. It's harder in criminal law, as it should be, to find somebody guilty of committing a crime. So let's apply what we've learned to some examples. So is this primarily a civil or a criminal matter? Failure to pay rent. Well, it is a civil matter because a rental agreement with a landlord and a tenant is a contract. So if one of the people fails to end up to their end of their side of the contract, that would be a breach of contract. How about knowingly making false statements to harm someone's character, such as defamation? We have a recent example of Fox News, defaming the character of Dominion voting machines. And another famous one is the Alex Jones defaming the character of people whose kids had been involved in mass shootings. And both Fox and Alex Jones were found to be responsible parties because that defamation is not a criminal matter, but it is a civil dispute. Knowingly making false statements in court under oath, if you perjure yourself on the stand, that is criminal, and that's a criminal perjury. And why do we know that? Because it's defined in criminal law. How about hunting a federally protected wildlife? Is that criminal or civil? It's criminal because in federal law, it tells us that certain animals are protected, and if you engage in harming or killing those protected animals, you've committed a federal crime. How about not paying child support? Willful failure to pay child support. Well, that is a criminal offense. In laws that were passed in the 1990s, it's a federal offense to not pay your child support if you are able. How about copyright violation? Is that a civil or a criminal matter? It's actually both, okay? And so there are federal laws prohibiting taking somebody's property rights from them. But if it is, the intellectual property, right? So a copyright violation. However, you can sue somebody in civil court if they have used your materials, your songs, your art without your permission. So that's an example of both. Okay, so let's now turn our sights to looking at the organization of the judiciary, the court system in the United States. Now, as we know, in the United States, federal law is supreme, and that is established in the Supremacy Clause, Article 6, Section 2. And what the Supremacy Clause is basically saying is that federal law takes precedent over state law. So if there's ever a conflict between state law and federal law is the one that triumphs, right? It's the one that takes precedence over the state or local law, okay? And so what that means is if there's a conflict between state law and the federal constitution, right, then the federal constitution takes precedent over state and local law. The United States is also a federal system, which we know it's divided between, powers are divided between the national government and the state governments. And we also know, because of the 10th Amendment, that the so-called police powers, that is the power to regulate safety, public health, morality, people's welfare, that police power is reserved for the states. And so when we look at the way the courts are organized, you're going to see that a lot of criminal matters go through state courts, not the federal courts. And so that, 90%, if not more, of criminal cases work their way through the state system side of the court system in the United States. And likewise, the vast majority of people who are incarcerated aren't incarcerated in federal prisons, but they are incarcerated in state prisons. And so as we'll see, that these principles of federal supremacy and of federalism are reflected in how the United States court system is organized. Okay, so here is a diagram of a rough outline of how the court system is set up in the United States. We're going to just take a look at this first, and then we're going to talk about the different types of courts. Then we'll return to this slide so that we can sort of see it, kind of apply what we've learned. Okay, so on this side is the federal system, okay? So any case having to do with federal law goes through the federal side. This is the state system, okay? Any a law having to do with the state law or state constitution goes through this side, okay? Now, this side is set, and we'll talk about how that's set in a moment. And then this side, though, is different. Every state has their own organization of this court system, and they might have different names and different organizations, but in general, they have a trial court, appellate courts, and Supreme Courts. That both the state side and the federal side can make its way to the request for a review at the Supreme Court. That's a request for a writ of certiorari, that you have no right or obligation, or the court has no obligation to hear your case upon review for the final time. But if it does accept it, then that case would be heard by the Supreme Court. And as federal law, as we know, the federal supremacy, that the Supreme Court, basically when it comes to the judiciary, has the last say on the matter. So now let's go in and talk about what the difference between appellate or trial, appellate, and Supreme Court courts are. And then we'll return to this diagram so that we can put more details in terms of each of those levels on each side. So as you saw on the slide, on the last slide, there are three types of courts that make up both the state court system and the federal court system. The first court is known as the trial court. And the trial court is what's known as the court of original jurisdiction. That means that it's the court that hears a case for the very first time, hasn't been heard by any other court. That there are both civil trial courts and criminal trial courts. A good example recently of a civil trial is that the former President Donald Trump, right now in New York, is that there is a trial going on regarding the valuation of his property. And he's been attending court, and there's been testimony that's been going on. So it's a good example of a civil trial. So just keep that in mind. The trials happen with both types of law. What happens at a trial court? Well, each party comes and they try to settle the dispute. And so in a criminal case, the government shows up, they tell their side of the story. The defense shows up, they tell their side of the story. And then a verdict or a decision is rendered. And so evidence will be presented, a testimony, opening and closing statements. There could be a jury, and that ultimately the conclusion of the trial is the rendering of a verdict. In a criminal trial, guilty or not guilty. In a civil trial, responsible or not responsible. So that's what happens in a trial court. An appellate court, as the name sort of indicates, is that it's a court that hears a case on appeal. They don't have an original jurisdiction. They have appellate jurisdiction. That means that they can only hear the case after it's been heard by another, by the lower level trial courts. And so basically the appellate court hears the appeals of the trial court. And so let's say that you are tried and you are convicted of robbery. Well, you might feel as if that conviction was made in error, okay? And so that you take it to the appellate court. Everybody has a right to one appeal at the appellate court level, at least one appeal. And you basically say, look, I was found guilty, but there were errors. I had a really crappy defense counsel. They were drunk during half of the trial. That evidence was admitted that was unconstitutional, was illegally collected, etc. And so then the dispute that is settled is over whether or not there was an error. Now, unlike a trial court, there is no testimony, there's no trial, okay? But that what happens is that each party, whether it's civil or criminal, presents a brief. And the brief makes a case for why there was an error at the trial court and why there wasn't errors at the trial court. And then the appellate court reads those briefs and that they render a decision. Now, keep in mind, in a trial court, there's one judge. In an appellate court, there's usually more than one judge. It's a group of judges, a bank of judges that make the decision, and then majority would rule. That there's three decisions that an appellate court can make. The first is that it affirms the decision of the trial court, and so it basically says that the decision in the trial court stands. They can remand the case back. They can basically say there were some errors, but we're sending it back to the trial court for further hearing. And then they can also reverse the decision of the lower court. They can say that due to grave errors, that the decision in the lower court was wrong, and they can basically vacate or reverse that decision. The Supreme Court is also an appellate court for the most part. As we'll find in the next lecture about the U.S. Supreme Court, there are times when the U.S. Supreme Court acts as a trial court, but very infrequently. But the difference between the lower level appellate courts and the Supreme Court is they are the court of last resort. They're the highest court in the system. They usually serve an appellate function. But what takes place in the Supreme Courts is very similar. Briefs are submitted and read at the U.S. Supreme Court. There are oral arguments, and there's oftentimes oral arguments at state courts as well. And then after that information is heard, then the Supreme Court justices will take time to decide that case. And then, just like in an appellate court, they will render a decision on the dispute that is ahead of them. And so that brings us back to this diagram, and so that we can kind of, I think, understand it a little bit better. So let's do the federal system first. On the federal side, the U.S. district courts are the trial courts. That's where trials take place. And so if you're accused of a federal crime or you're being sued for a federal matter, you're going to end up in U.S. district court. That's where the trials take place. There are 94 U.S. district courts throughout the nation. Every state has one. Wisconsin has two, okay, depending on the size of your state in terms of population, because the more people that live there, the more you're going to need federal trial courts. The intermediate appellate court is known as the U.S. Court of Appeals. Sometimes they are known as the U.S. Circuit Court. There are a total of 13 U.S. courts of appeal, that there are 11 that are dedicated to different regions within the country. And so, for example, Wisconsin is in the 7th Circuit Court of Appeals. The 12th Circuit is for D.C., and the 13th Circuit is for broader federal matters like patent violations, okay? Briefs are submitted here. There's a bank of federal judges that hear the case. Then they will write up their decision, okay? And so that's this side. You have the same thing that takes place in at the state level. There's state trial courts. I won't go into too much detail here, but like in Waukesha, you have the Waukesha Circuit Court. That is the trial court. We have a series of state intermediate appellate courts, and of course, we have the Wisconsin State Supreme Court. Now, as I mentioned before, that each of these, if that can be requested for a final appellate review by the Supreme Court of the United States. Okay, that's it for me in this lecture. And so thank you for listening. On our next lecture that we are going to be learning about more details about the U.S. Supreme Court. And I really encourage you, and in fact, there will be a question on the lecture quiz. Make sure you watch that short video from Vox about how a case gets to the Supreme Court. It's a real nice overview of the material that they talk about in your chapter. All right, thanks a lot for your time and attention. I appreciate it, and talk to you again real soon.